Hello.
Good afternoon.
Pam, is my volume okay?
I can hear you.
All right. Great. All right.
Ready for me to start the
Hit
recorder?
record, please. Sorry?
Got it.
All right. Thank you. Do we have everyone we need here? I see.
Hi, Teresa. This is
Lorraine?
We're expecting Pete. We're expecting Pete too.
Okay. We can wait a minute.
Okay.
And Emily Bowen may or may not join us. I'm not sure, from the, I would say, the Attorney General's office, the Department of Justice.
I can send her a quick text. Yeah.
Oh, there's Emily.
Yep.
Lorraine, can we start without him?
Yeah, let me send him a text. And that would be fine.
All right. So let's just begin with introductions. I'll go in a circle here on my screen. My name is Felicia Orth, hearing officer appointed by the EIB. It was a surprise to me, by the way, that I was appointed to help them with the stay motion. I wasn't expecting that. Pam Jones, who is the board administrator. Let's see, Mr. Maxwell. Nicholas Maxwell. Ken Ortiz.
Good afternoon. I'm here. Thank you.
Hello. Mr. Nye.
Good afternoon.
Good afternoon. Mr. DeSalen.
Good afternoon. Charles DeSalen, representing Coalition for Clean Affordable Energy. Thank you.
Thank you. Mr. Bach.
Good afternoon, Madam Hearing Officer and parties. David Bach on behalf of Climate Advocates.
Terrific. Brecken Scott.
Hi, Brecken Scott for NMED along with Andrew Knight.
Thank you. Deborah Kapeloff.
Good afternoon, Hearing Officer Orth. Deborah Kapeloff here, not in an official capacity, just listening in.
All righty. Let's see. I see Ms. Bowen, who is the board's counsel. Aaron Kresick may have stepped away. And Mr. Domenici, I see you on the screen now.
Sorry I'm late, Madam Hearing Officer. Good afternoon.
You're just a little quiet.
Oh, let me, how's that?
That's much better. And of course, Ms. Hollingsworth, your colleague.
Yes, she's on the line too.
She is. All right, let's get started then. We are on a virtual platform in the matter of proposed amendments to 20.2.91 of the New Mexico Administrative Code. These are new motor vehicle emission standards, docketed by the hearing clerk as, or the board administrator as EIB number 23-56R. We're on the platform to discuss, as I understand it, the process by which arguments or evidence will be accepted by the board during the meeting scheduled on March 22nd. Around the motion for stay filed by Automundo de Garcia and the New Mexico Automotive Dealers Association. Let's see here. I am open to all discussion, obviously, on this process. I think we're going to need some time limits so as not to let it get out of hand time-wise. And who would like to begin the discussion? This, of course, is the motion for stay being heard under the board's regulation 20.1.1. I think it's section 501.
Madam Hearing Officer,
That's
Andrew
fine.
Knight. If-
Yes,
Oh, good.
Mr. Knight.
Well, I just wanted to start by saying that NMED had anticipated and planned that this motion hearing would be handled in the same way as the EIB has handled past motion for stay hearings, the last being in August 18th of 2023 in matter EIB 2234. Where a board member served as the hearing officer. In that case, each party was given 10 to 12 minutes to present oral argument, followed by the EIB asking questions, and then the board deliberated.
All right. Mr. Domenici?
Yes, the presentation I made to the board, which before they scheduled the hearing and agreed to hold the hearing, was requesting 90 minutes. That would be for a combination of argument and testimony. I don't think my clients have had a chance to put on testimony regarding irreparable harm. So I think that would be appropriate for evidence on that. The other main issue is likelihood of success, which would mostly be legal argument. But I had requested 90 minutes for my case, probably about 20 or 30 minutes of that would be argument, an opening and a closing. And about 60 minutes would be testimony of, I think, 4 witnesses and some exhibits that they would refer to.
Madam Hearing
All right.
Officer,
Yes,
David Bach
Mr.
here.
Bach.
My climate advocates oppose any additional evidentiary presentation for a couple of reasons. First, the motions didn't request an evidentiary hearing. The motions were based entirely on legal argument and the testimony that was already presented in the November hearing. I think there were, to be fair, I think there were a few letters from legislators that post-dated that hearing. So I suppose we don't object to that being considered. But we certainly don't believe it's fair to the other parties, and in fact, it would be prejudicial to allow an hour of new testimony, especially since nothing's been pre-filed. We have no idea what it would be. And if there is testimony for an hour, we would anticipate cross-examination. We would anticipate probably wanting to have rebuttal witnesses. You can't just open up the record a little bit. If you open up the record, everyone has to be able to fairly participate in that process. And particularly since no request was made in the motion to open up the record, it was based entirely on the evidence already before the boards. I don't think it's appropriate. I think a legal argument based on what's in the filing, what's in the papers, is the appropriate way to handle this.
So, Mr. Bach, how then would the movements be able to establish that third or fourth prong for a stay of irreparable harm, for example?
Well, we don't think they can, but we think that the fair way to do it is I mean, every stay motion that I've litigated, when you file the motion, you include a declaration or you include some evidence on that factor. And here I think they do include they do refer to the testimony that was already filed as the evidence they're relying on. So that would be what they would say, because they would say, well, we have irreparable harm because, as we already told you, in the testimony of Mr. Ortiz or Mr. Garcia, this is going to, lead to people buying cars out of state. It's going to be very detrimental, whatever arguments they want to make. I anticipate the arguments are going to be similar, but it does seem to me that they should be limited to what they put in their motion, because, realistically, next week is spring break for a lot of us. For us to actually be able to prepare to respond to brand new arguments that haven't been in any of these motions, it's going to be very, very tough and time consuming. With that said, if you were inclined to allow testimony, we would at least request that something be pre-filed so we can kind of understand if we want to put on our own evidence, etc. We have an opportunity to plan.
Okay, thank you. Mr. DeSalen?
Thank you. I think Ms. Bowen may have been in line before me, so I'll defer to her.
Ms. Bowen, would you like to speak now or wait till after we've heard from Mr. DeSalen?
I just wanted to note that it is the petitioner's burden, and allowing him the opportunity to meet that burden is required here. And I don't think that precluding them from presenting their case in order to meet that burden would equate to a fair hearing.
Okay, I understand. Thank you. Mr. DeSalen?
Yes, thank you, Madam Hearing Officer. Just a couple of quick points that I want to make. And I second everything that Mr. Bach said. But first of all, I want to point out that there's nothing in the Air Quality Control Act or the board's procedural rules to suggest that the automotive dealers are entitled to have an evidentiary hearing on a stay motion. Both the Act and the EIB rules refer to a motion for a stay, and they do mention a hearing, but hearing on a motion does not usually include testimony or the introduction of any additional evidence. And neither the statute or the EIB rules here say anything to suggest otherwise. So this, in our view, this should simply be a motion hearing based on legal arguments. And as far as evidence on irreparable harm, the automobile dealers have already had ample opportunity to make these sorts of arguments in the original hearing that was held. So the Air Quality Control Act specifically provides, in considering a rulemaking, the Environmental Improvement Board has to give the proper weight and give consideration to, well, there are several things, but a couple of things are particularly important here. First of all, the public interest, including the social and economic value of the sources of air pollution. And then the second thing is the technical practicability and the economic reasonableness of reducing or eliminating the air pollutants that are involved. So the automotive dealers have already had their opportunity to put this type of evidence on, which is the same type of evidence that they would put on to establish irreparable harm. And there's nothing in the statute to suggest that they get a second opportunity here. And not only they had the opportunity to put on this type of evidence, they put on lots of this type of evidence. They had something like 12 witnesses at the hearing that talked about how this rule, if promulgated, would hurt their businesses. Thank you, Madam Hearing Officer. That's all I wanted to say.
All right, thank you, Mr. DeSalen. I guess I have a couple of questions. And I didn't ask Pam this, I guess I might have. Is there a particular reason that the hearing has been set on March 22nd Is there some deadline that we're trying to beat by having it on the 22nd?
We'll let Emily field that.
They just, there's not a deadline. That was just when their regularly scheduled meeting has been already designated for, and so we figured we would schedule it all at the same time.
Okay. All right. And the reason I'm asking, well, two things. One, as I explained to Pam when she surprised me with a text about being appointed, I may or may not have a municipal court trial that I have to do up here in Los Alamos. If the regular municipal judge has to recuse herself, I have to step in. And I won't know that today. I'll know it sometime, presumably next week. But the other reason I'm asking is, on the one hand, we have, nearly a week's worth of evidence in the record already, and to the extent that the evidence in the record can be cited in support or in opposition to the motion, I think that ought to happen rather than hearing it again. My impression was the board members were paying close attention throughout that hearing, and it doesn't need to be repeated. So I want to avoid redundancy. At the same time, I guess I feel like a motion for stay contemplates potentially different evidence than a petition for rulemaking. There'll be some overlap there. And so I do want to give the movants an opportunity to specifically address the 4 prongs necessary to get a stay. But then the third consideration, obviously, is it shouldn't be a surprise. We should not be gathering on March 22nd in order to hear this evidence for the first time. And I'm not suggesting something as elaborate as all of the pre-filed direct and rebuttal testimony that we did for the rulemaking. But my memory of stay motions before I was a hearing officer was that affidavits and things were attached to the motion. Someone mentioned that just now, that often it's affidavits or other statements attached to the motion that provide the evidence that can be relied on in in acting on the motion. So that's all of the things going through my head, perhaps too much. So let me turn to you, Mr. Domenici. Knowing that I want to avoid surprise, knowing that I want to avoid redundancy, but also knowing that I'd like you to be able to have an opportunity to support your motion with evidence that if it didn't come in during the rulemaking hearing, it didn't come in. And if you feel like you need it as part of the stay motion, I want you to have a chance to do that, but also not in an elaborate way. Again, not a surprising way, not a redundant way, not an elaborate way.
We're prepared to do something like a notice of intent for our witnesses. We think it would be probably important for them to be there to potentially answer questions from the board members, because that was part of the hearing. And so, but we don't intend to try to surprise anyone. I wasn't thinking about spring break as much, but I recognize that. I have quite a few other clients, other people, that have trips next week. But we were planning to propose some kind of deadline for us to provide. We think we're going to have 4 witnesses. We'd provided an NOI for them with any exhibits they would refer to, probably by next Friday. but that we're flexible on that schedule. And then they would stand for cross-examination by the board at least, or questions by the board, whether it's cross-examination or just questions. I think the way that the model year actually works within the auto industry and varies from manufacturer to manufacturer is very critical. And one of the reasons why the harm we feel may be irreparable, in the sense that the appeal may be pending while some 2027 calendar year models are certainly being constructed and perhaps being delivered. So the timing and the way that model year works and the way that the dealers and customers are going to have to adjust is really the focus. But if there's some other way, I don't think affidavits are what I typically see. I view a stay motion as comparable to a preliminary injunction standard, which usually, in my experience, contemplates live testimony.
All right. So you're suggesting you could have an NOI shared with the rest of us by March 15th. That's next Friday.
Yes.
Okay. Comment or suggestions from others around that? Mr. Bach, for example?
So, and I think, I think that sounds like it could be a good compromise. What are you thinking is what exactly do you mean by an NOI? I mean, because you said you kind of distinguished it against pre-filed testimony, or did you? Is it going to be the full testimony they're going to provide, or is it going to be what are you like? What level of detail are you thinking?
The full testimony. Pre-filed testimony, like at the last hearing.
Okay, then I actually think that's a really that I think that is a very workable idea. I'll still be in Mexico surfing when you file it, but I can look up on the plane back.
Okay.
Madam Hearing Officer, if I could suggest that, since we're going to have pre-filed testimony, if we could have the witnesses provide similar to the hearing, if they could provide a summary of that testimony with time limits of like 15 minutes per witness or something. Again, I think that would be a good compromise, and just so we don't turn this, the EIB, this is one item of several on the EIB's agenda for that March 22nd meeting. So I think if we can agree on some time limits ahead of time so that we can enforce those if needed during the motion hearing.
So, Mr. Knight, I believe Mr. Domenici proposed actually exactly, he said 4 witnesses. He proposed 60 minutes for all 4 of his witnesses. That would be about 15 minutes each if they took exactly the same number of minutes.
Yeah.
Right, Mr. Domenici?
Yes, that's correct.
All right. Did I see Mr. DeSalen's hand? Sorry.
Yes, Madam Hearing Officer, I just wanted to, I guess I initially wanted to ask if what Mr. Domenici was proposing has kind of been answered now, was that his witnesses actually present the testimony at the hearing, or if they just submit written testimony and then stand up for or get on the stand for cross-examination, which is sometimes the way these kind of things are handled. And then my other point was I wanted to make sure that if there are time limits, that there should be time limits, and that it should be the total amount of time per party as opposed to per witness.
Okay, so in my observation, I certainly read everything before I get to a hearing in order to prepare. And in my observation, the board members also would read testimony attached to an NOI before then. And so they certainly don't need a witness to, read their narrative testimony word for word. That can get tedious as you follow along. But again, however Mr. Domenici would want to use that 60 minutes for his 4 witnesses, and then those witnesses would be subject to questioning by the other parties, by the board members. It needs to be explored.
And if anyone is going to call witnesses, I would like an NOI from them at least a day or 2 before the hearing.
Yeah, I was
The other parties.
going to mention that it's quite tight turnaround, but I think that's only fair.
The 20th is Wednesday.
I think the 20th is doable as it can be. So I think the 20th is fine for me. What about you, Andrew?
Yeah. I think we'll need to see the NOI before we know how we're going to respond to it. But I think again, given the compressed timeline that Wednesday is it's as good as we can do. I just wanted to mention that we don't want to forget that that parties need time for their legal argument as well, and that needs to be added on or considered in this context that we're all going to want our allotted amount of time to do the regular motion argument.
So, Mr. Knight, you had mentioned the earlier stay hearing argument time was 10 to 12 minutes. Mr. Domenici proposed 20 minutes for argument, which would incorporate, both opening and closing, for example. Any comments on that?
Only that that's not the way the EIB has done things in the past. But I don't know that they've imposed strict time limits. But what we've seen is 10 to 12 minutes total per party for their oral argument.
Okay.
Just a comment here. I mean, do we have a sense of what the total amount of time the boards can realistically give this hearing? Maybe we should start with that global high, as it were, and then divide it up.
So, good question, Mr. Bach. I did ask Pam before the rest of you got on the platform how many other agenda items the board had that day, and she said there was just the one, which was a new rulemaking petition. I think it was air quality rules of some kind. And of course, it's not a hearing. They would merely be setting that petition for hearing. Typically, it doesn't take very long for the board to accept a petition and then find a date for hearing, decide whether they need a hearing officer. So I think we had most of the day. And of course, that short petition acceptance would come before us. Other questions or comments?
It seemed like the board was interested in making sure they were able to hear this argument in the limited discussion they had. So I don't, even the order says it would continue the next day, I think, or continue into the following day. So I don't think we're, taking a half day should be a problem if that's what it takes.
The next day is a
That was-
Saturday, I believe.
Well, it says,
Yeah, the
it
next
does
day
say
is Saturday,
continuing on further days, the order appointing you. So they were contemplating potentially more than one day even.
Okay, so fortunately or unfortunately, I'm leaving the next day for Capitol
No
Reef.
problem. I just wanted to make sure you understood that they weren't limiting this. At least that's my view.
I'm
I
assuming
think-
that since they called me, they want this fully fleshed out. That's what I'm assuming.
Okay.
Ms. Bowen, I'm sorry. Did you want to say something?
No, I agree with that. That was what I was going to say as well.
Okay. Any other observations before I provide a recap here? Yes, no? All right, let me give it a shot. The move-ins will file pre-filed testimony for what they believe now to be 4 witnesses by March 15th. The opponents to the motion will file any pre-filed testimony they would like to offer by March 20th. Regardless of the length of the written testimony, verbal summation of that testimony shall not exceed a total of 15 minutes per witness. Argument, let's cut that in half between 10 and 20. So let's just do 15 minutes per party for oral argument. Witnesses obviously will be subject to cross-examination. That's by other parties and by board members. We'll assume there won't be anything resembling rebuttal for now. And we will potentially start just a little later than 9 a.m. Depending on what I hear from the Los Alamos Municipal Court, and I'm sorry about that. That's been scheduled for a while. Did I miss anything? No? Okay.
So, Madam Hearing Officer, I think this is implied, but I think that there's been a representation that the total testimony per side would be limited to 60 minutes, which I think you implied by saying 15 for the 4. But if anyone has more than 4, it'd still be 60, right?
Right. We need to move on, and anything that's really important ought to be in their written testimony anyway, in my opinion. All right. So I will write this up, and to the extent other questions are raised or something else comes to mind, please just hit reply all so that we're all included on the email conversation. I'll let you know as soon as I know whether I can start promptly at 9 a.m. or promptly after the one rulemaking petition is set for hearing. But I think even if we start a little later in the morning, we will still be able to get through this on the 22nd. I believe that. Oh, Mr. DeSalen.
Yes, Madam Hearing Officer. One other question here, sort of logistically. Some of our witnesses may be from out of state. And I'm presuming that this is going to be an in-person hearing, but we may want to put some witnesses on virtually if that is acceptable.
All right, let me throw to the expert here. Pam, are these set up to accept statements virtually?
Yes, we'll have a WebEx link for those who can't attend in person.
Terrific. Much more interesting than in the old days when we used to borrow a telephone from the state capitol building guys and set it in the middle of the dais and take people's testimony over a phone. All right. Anything else that we can talk about while we're together? And again, in the event I have left anything unsaid in the order that I'll type up, please reach out.
Further here, thank you.
Okay. Thank you so
Thank you.
much.